Good morning, TGIF. Welcome to House Judiciary. Here, will you call the roll?
Representative Brady,
Here.
Representative Breton,
Here.
Representative Chestek,
Here.
Representative Filer,
Here.
Representative Kelly,
Here.
Representative Lean,
Here.
Representative Singh,
Here.
Representative Webb,
Here.
Chairman Washit.
Here.
You have a quorum.
Thank you. Representative Smith, we finally got your bill. Yeah.
Okay, well, good morning, Mr. Chairman.
Good morning. Welcome, and tell us what you want us to know about House Bill 111.
Okay, well, thank you, Mr. Chairman and committee. Today I'm going to present House Bill 111. It's hit and run responsibility and penalties. In essence, it's an act relating to motor vehicles, increasing penalties for failing to stop where an accident involves serious bodily injury or death, and it's adding a knowledge requirement for specified failing to stop offenses and providing clarifying amendments. And in essence, this is one of those lovely constituent bills, and it's an unfortunate constituent bill because since 2021, one of my communities in my district has had two similar situations that individuals, pedestrians, were struck by a motor vehicle and left. And the drivers did not render any aid and drove off. Fortunately, we have a great police department that does a lot of great detective work, and both times they were able to find the vehicle driver. And but they have found through the legal process that there's some gaps in our law. And so I'm going to hand it over to our police chief, Matt Johnson from the city of Torrington, and he'll share a little bit about those circumstances and the gaps that he found in the law and what he's hoping to accomplish through this bill.
Welcome, Chief.
Thank you, Mr. Chairman. Thank you, committee. As Representative Smith mentioned, I'm Matt Johnson. I have the privilege of serving the amazing community of Torrington, Wyoming as the Chief of Police. I've been there since 2020, and it's a great place to be. Thank you for giving me a couple of minutes of your time to talk about an issue that has been really important and frankly, sadly impactful in our community over the last few years. Essentially, what we're here to ask for your help with is closing a loophole in the Wyoming statute related to hit and run accidents that involve death or serious bodily injury. Right now in the state of Wyoming, if a driver strikes a human being, most often it's a pedestrian, causes death or serious bodily injury to that person, and then leaves the scene, unless that driver had criminal intent related to the collision, unless they were intoxicated, or unless they were driving with highly reckless conduct prior to the accident, it's very likely that they're only going to be charged and ultimately convicted of a misdemeanor crime. When you think about the lack of appreciation for human life that's involved in literally running over a pedestrian, causing them grave injury, watching them slide off the front of your car, and then leaving them for dead in the roadway, that hardly seems appropriate. And as we have worked with victims in our community, we have found that they often feel like that's certainly not justice for them and their families. We've had two of these in our community. Both of them were ladies that were out getting their exercise for a walk. They were crossing the street when a driver did not see them, turned left into them, ran them over, and left them for dead in the roadway. Both of those ladies suffered horrific injuries. Both of those ladies suffered months and months and months of painful procedures and rehabilitation. Both of them have long-term and essentially forever either disability or impact that they're going to have to live with for the rest of their lives. And both of them incurred hundreds of thousands of dollars in medical bills as a result. Fortunately, both of the drivers in those cases were identified, one by us and one by assistance from the Wyoming Highway Patrol. They were apprehended and charged, but ultimately only convicted of misdemeanor crimes. We feel like, given the pretty serious nature of this and the horrific impact that it has on victims and their families, that this is a crime that ought to qualify for felony. And we would ask to increase that penalty from 1 year, $5,000 max to 5 year, $50,000 max. We believe that that gives police officers, prosecutors, and judges the options that they need to provide justice for victims who are horrifically impacted by these types of crimes. We're grateful for the support of WASCOP on this issue, and I guess I don't really have a lot of other things to offer, but I'm happy to stand for any questions or offer any other perspective that's beneficial.
So Chief, you mentioned if you're driving under the influence and you hit somebody, that's a serious crime, right? It's an aggravating factor.
It is very much so.
But if you leave the scene and hide out long enough to get sober before you're identified, you escape all that and only get charged with a misdemeanor. Is that what you're explaining to us this morning?
That is definitely a possibility. Specifically what I was referring to in this discussion is vehicular homicide. If you hit someone and you're intoxicated, that automatically elevates to the potential for the charge of vehicular homicide. But the circumstance that you brought up could also take place.
Committee questions? Vice Chairman?
Thank you, Mr. Chairman and Officer, for being here today. So can you just specifically, what levels of blood alcohol content are you referring to when it pertains to intoxicated or not?
Chief?
Mr. Chairman, am I good? So that would be just the standard .08 DUI statute. And that doesn't apply to the bill that we're proposing. That would apply to a separate statute under vehicular homicide.
Follow up?
Thank you, Mr. Chairman. I apologize. Chief Johnson.
No problems.
Representative Shestak?
Thank you, Mr. Chairman. Chief Johnson, I have to admit that I was a civil practice lawyer. I didn't do criminal law when I was in practice, so I'm not familiar with the criminal laws that much. Is a DUI the only situation in which vehicular homicide can be charged? I mean, if somebody's not drunk, but they're speeding or something, some other kind of aggravating circumstance, could that be elevated?
Yeah, there are.
Chief?
I'm sorry, Mr. Chairman. Am I okay to answer? Thank you. Yes, sir. And I apologize for
Yeah,
getting
it's a little routine you're not
my
used to. I
routine.
understand that.
Yes, sir, there are. Some of the other circumstances, I don't know that I could list all of them today, but certainly if you're looking at extremely negligent conduct in the operation of the vehicle, if you're looking at intoxication, if you're looking at some form of intent to cause harm. I've got the statute. I could review it with you, but I don't know for the sake of time if you would want me to do so.
Further questions for the Chief? Representative Webb?
Thank you, Mr. Chairman. My question would be, in the course of the investigation of these two incidents, was there any intent found on the part of the driver? Was you able to determine any intent?
Chief?
Mr. Chairman? No. And that's one of the reasons that we think that this is so important. In both cases, the offending party was making a left-hand turn and just failed to see a pedestrian crossing their path. And that really is kind of the hang-up that we see with that loophole in statute. If people just stop and render aid and save that person's life, if possible, there may or may not be significant criminal repercussions. Where we need the serious repercussions is when you run someone over, know about it, and then flee the scene and effectively leave that person for dead. That's really where this comes into play.
Representative Smith?
Thank you, Mr. Chairman. So if you guys look on page 2 of the bill, one of the major contributing factors about this penalty is found on line 1, page 2, and what we're changing is who is knowingly involved. And I know oftentimes that word knowingly is debated a lot. How do you know that you injured someone? Well, in both of these cases, the individual went up over the hood, or at least one of them for sure, went up over the hood. You know, you break the windshield, have to slam on the brakes, veer the vehicle to get them off your vehicle. So both times there was a lot of evidence that the individual knowingly did this. You know, it would be different if you're making a turn in a semi truck and the rear end of the trailer hops the curb where a pedestrian may be standing and injures them. They may or may not knowingly have injured the individual. So I think the main part about the bill is page 2, line 1, knowingly, and then page 2, starting on line 22 on to page 3, as far as adding the penalty for a felony. So that is essentially the difference of what the statute currently reads, you can see, without all the underlining. And so we're just trying to look at adding the knowingly and the felony component. So that's what we're here for.
I saw we just had another case like this up in Bighorn County, or Hot Springs County, yeah. Further questions? Representative Chestic.
Again, I apologize for my lack of knowledge of criminal law. Is there another statute that deals with property damage? Maybe there's an incident where you run into a parked car, or there's some kind of serious property damage and you still leave the scene of that. That's not covered by this statute. Is that covered someplace else?
Chief?
Mr. Chair. Yes, sir, there is a separate statute for property damage only. And really, those are broken up into 2 statutes. The first only deals with the property damage. The second, which is what we're working on today, was intended, I think, to incorporate all injury, specifically death and serious bodily injury. If I could add just a touch to what Representative Smith had mentioned, the interesting part of this death or serious bodily injury is that the way it was written, it's technically an inchoate offense where you don't even have to know what happened in order to be charged with it. And in our criminal justice system and from a law enforcement perspective, I really don't want to be charging people with crimes of this type that they didn't know occurred. And I think that that's an important burden of the state, that we were able to document that a person acted knowingly, was aware that they had an accident and then left, having caused injury to another person.
Follow up?
So now you take me back to my first year criminal law class. This is the mens rea element, right? You have to, the knowingly is the mental state that you have to have in order to commit the crime. If you don't know it, there's no mens rea. Is that what you're saying?
I'm sorry, Chairman.
You're not up on Latin today, right?
I haven't studied my Latin, but from my past business law classes, I believe that you're correct.
Okay, Pierre, I think we have somebody online waiting on Zoom. You want to bring them in? Griffin's, Mr. and Mrs. Griffin. I got a text message from them or voicemail the other
Is
day.
it
so-
Andrew? Oh, that's awesome.
Good morning to the Griffins. Can you hear me? Mr. and Mrs. Griffin, are you there?
I'm here.
Good morning. Welcome to House Judiciary. Just direct all your comments to the chair and tell us what you'd like to hear, like us
Thank
to.
you, thank you, Mr. Chairman, members of the Judiciary Committee. My name is Andrea Griffin. I live in Torrington. I am one of the people that the chief was talking about on October 26th of 2022. I was crossing the highway in Torrington in a crosswalk with time on the timer to get safely across the street, the highway in this case. At approximately 7:03 in the morning, I was hit and left for dead in the highway. This bill is extremely important to me. All I can do is tell you a little bit about my story. I hope not to get too wordy. I tend to do that. But the chief has covered a lot of what I feel, and he and I have talked about this. In my case, the man certainly knew he hit me. Of course, he denied that at first, but eventually, yes, he admitted that he knew he had hit me. Had there not been cameras on a school bus, I'm not sure he would have been caught. When I woke up in the highway, the school bus driver was cradling me in his lap in the highway at a very busy time. When I woke up and I was trying to stand, and he's holding me down and saying, don't move, you might have more injuries. And I looked up, and there stood my brother, who happened to be on his way to work and saw something going on in this highway, and looked down, and there's his sister laying there, so broken. I couldn't get up. I couldn't move. My injuries were very severe. I had several skull fractures. The left side of my face was basically crushed. My left arm was so severely injured. He had to have run over my arm. My elbow was broken. My wrist was shattered. My fingers were broken. My right wrist was broken. My left hip below the hip socket was broken. I have a lot of nerve damage to this day. People will say to me, gee, you look really, really good, which is a real blessing and a real curse. Because if I could turn myself inside out and you could see all the damage that I deal with on a daily basis, you would understand I'm really not okay. And that's the physical things. The mental things are astronomical to boot, the PTSD. And listen, I don't want to ruin the life of the man who hit me, but he needs to be accountable and he needs to take responsibility. And at this point in time, I don't know that he has really done that. He's accepted the fact that what he did. But it was a misdemeanor. I had to be life flighted from Torrington to Greeley. I spent 3 weeks in a hospital. I spent 3 months going to physical therapy. I can't tell you how many hundreds of thousands of dollars this cost, not just taxpayers, but certainly insurance companies. The man who hit me had no insurance. So this bill is very near and dear to my heart, and I'm not the only one that has been through this. My family is not the only one that's had to go through this. My friends are not the only ones that have had to go through this. It's becoming clear to me that this is a ongoing situation that needs to be taken care of. And all they have to do is stop. If he had stopped, number one, maybe I wouldn't have, there was traffic moving back and forth and I was in the highway. If he had stopped, perhaps he could have kept vehicles from approaching. I just want House Bill 111 to pass. I can't. The other thing is, you talk to anybody in the state of Wyoming and you tell them a hit and run situation such as mine is a misdemeanor, and their mouths drop to their knees. They can't believe it's not a felony at this point. So I strongly encourage you to pass House Bill 111. And I appreciate your time and listening to me, and I appreciate the chief and Representative Smith for taking on this obligation. Thank you.
Thank you for your testimony. Powerful story. Committee, any questions from Ms. Griffin? Representative Filer.
Thanks, Mr. Chairman. I got a phone call last night from one of my constituents about this bill, and they love it. But when you get all the way to page 3, where it says on line 5 on section 2, it said, "This act shall apply to all motor vehicle accidents." The one issue that they had, and I told them, I says, because I'm no attorney by any stretch of the imagination or anything like that, but they asked, with this bill, would this help alleviate a problem they had? And their problem was, his wife works at a Lowe's store, a home improvement store, and her vehicle was struck while she was at work, to the point of almost totaling the
Representative
vehicle.
Filer, is this a question for Ms. Griffin?
It is.
Okay, all right.
But her vehicle was struck while she was in the store, and it caused a significant amount of damage to the vehicle. And I think this kind of piggybacks off of what Representative Chestic was saying is, but this bill does absolutely nothing for that person that hit her vehicle, ran, they never caught the person, and now she's stuck with a large bill or having to buy a brand new vehicle. But in this section, it does say this applies to all motor vehicle accidents, but it's all about bodily injury, has nothing about personal property damage. And I know that we talked about there might be 2 different statutes here, but is there any way to encompass both of those where it's bodily injury and maybe this much property damage, a certain amount, put into this bill to give it more teeth for something like that?
Ms. Griffin, if you can answer that.
Ms. Griffin really can't answer that. I certainly understand wanting somebody to have to pay for the damages done to their vehicle. But I don't know that applies to this particular bill.
Maybe Chief Johnson can answer that.
Thank you.
I thought we were done with that testimony.
That's why I tried to intercede there. Okay. All right. Chief, you want to take a swing at that pitch?
Mr. Chairman, I'd be happy to. There are some states that incorporate all hit and run into a single statute, including property damage and injury aspects. Ours is not one that it does so currently. To my knowledge, the existing state statute related to hit and run involving property damage is adequate to prosecute. I suspect at some future time, it might be worth looking at what the dollar value is of the damages that are caused, because that can get to be quite impactful in this day and age. But for this time, what you are asking about is adequately covered by state statute for hit and run involving property damage. It's just 2 separate statutes.
But it never rises to a felony.
It does not rise to a felony to my knowledge. Yes, only the injury.
Okay. Any questions for Ms. Griffin? Let her go. Again, Ms. Griffin, thank you so much for being here this morning and appreciate your testimony.
Thank you, Chairman.
Anyone else in the room wishing to testify on House Bill 111? Representative, you can just stay there. Yeah. Little musical chairs. Mr. Thompson, welcome.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Chiefs and Sheriffs Association. And I would just like to echo the testimony we've heard from the chief this morning and pass on to you that our membership is in strong support of this bill. And I won't belabor the point, but if there's any more specific questions about the things outside of this bill, I might be able to answer some of them. The one thing that hasn't been mentioned today, if someone intentionally uses a vehicle to damage someone else's property to the extent of damage over $1,000, that could be a property destruction charge, separate from vehicle-related hit and runs and things like that. But we would have to prove that they intentionally use their vehicle to damage someone else's property. And in most cases with accidents, they lack that intent. But we are very interested in cleaning up the language in here about the intent and then incorporating the issues with the injuries, severe injuries and death. And I would be happy to answer any questions, sir.
Questions, Ms. Thompson? Appreciate you being here. Good morning.
Good morning, Mr. Chairman, committee members. My name is Lieutenant Colonel Carl Germain, and I want to echo support for this bill that was already previously testified to by Chief Johnson and Waskop. We deal with hit and run crashes quite frequently on the interstates and state highway systems. This is a good bill that would help prevent that as well as bring potential recourse to victims, because when they get hit and someone leaves and there is serious injury, they're left picking up the pieces. And if we don't apprehend that person, they're stuck footing the bill.
Lieutenant Colonel, especially on the interstate, when someone gets hit and left, it seems to me there's a high likelihood of another vehicle striking them again. Have you experienced something like that?
Mr. Chairman, I personally have not, but it's certainly not out of the realm of possibility. Fast-moving vehicles, and depending on where those vehicles come to rest, you always have a likelihood of secondary crashes.
Questions for the Lieutenant Colonel? Appreciate you being here this morning. Anyone else in the room wishing to testify on House Bill 111? Anybody left on Zoom? All right, going to close public testimony, give Representative Smith one last chance to sum things up.
Well, thank you, Mr. Chairman and committee. I just think that this is a good opportunity to help a lot of individuals out there. So I just pray it doesn't happen, but I think the main issue is knowingly, and in both situations in our communities here in Goshen County, it was easy to prove the knowingly factor. So thank you.
Thank you very much. Representative Filer.
Can I ask just one more question into the bringer? Page 1, lines 12, we're adding that new statute at 31-5-1101. It says duty to stop vehicle where accident involves death or personal injuries. If you was to, say, accidentally sideswipe a car driving, passing on a passing lane, and there was an accident, you didn't stop, but you didn't knowingly, you don't know if you hurt that person or anything like that, and you kept going. It's like a regular hit and run, because you might be, just thinking it was just some damage to the car, but just keep right on going, but that person had to pull over, and there was, bodily injury. Would they be able to get out of something like this because they didn't knowingly know they hurt that person that's in that car?
Representative Smith.
Mr. Chairman, may I phone a friend?
Chief?
Am I good? Chairman, Mr. Representative, that is an element of the crime that would need to be proven by the prosecution. And if it goes to trial, that's going to need to be proven beyond a reasonable doubt. But in the situation you described, there's a tremendous amount of reasonable evidence and direct evidence that could be presented by the prosecution to show that that person knowingly was involved in an accident and fled the scene. If you sideswipe someone, causing damage to their car and damage to your car, the likelihood of that occurring without you having a knowingly state is very, very low. There are circumstances where that could occur. I have seen some where a pedestrian took their own life by diving under the back tires of a semi. The semi driver had no idea. It's an 85,000-pound truck and a 110-pound person. So certainly it's important that we have that knowingly element in the statute, because it protects people from being unfairly charged if they weren't aware. But it's also a pretty provable element of the statute based on evidence and testimony.
Yes, Mr. Chairman, maybe, no, I understand they knowingly hit somebody. They, most likely, they got damage to their car and the other person. What I'm saying is, do they know, they don't knowingly know if the person was injured that they hit. So if they was to do this, yes, they obviously they already created a crime right there. They took off, they fleeing an accident, whatever it might be. But with that, I don't know how you'd be able to prove that they knowingly did bodily harm, because they know they did damage to a vehicle, but they don't know if they actually harmed that person or had an injury of the other vehicle. That's what I was getting at.
I think I can help a little bit here.
Okay,
So if you read the lines, it's the driver of any vehicle who is knowingly involved in an accident. So the knowingly element applies to being involved in the accident, okay? That results in bodily injury. So they just have to know that they were involved in the accident.
oh, we're good.
Is that correct? That's the way you read it, Chief?
That is how we wrote it, and thank you, Mr. Chair.
Okay.
Just want to make sure we're getting away with it.
All right. So with that, we're going to close public comment. And committee, what's your preference?
Move the bill.
Move the bill by Singh, second by Webb. Discussion on the bill? Any amendments? Page 1. Page 2. Representative Fowler, you're like a Jeopardy contestant on the button. All right. Page 3. Representative Fowler.
Thanks, Mr. Chairman. And last night, I was really surprised when I got some emails about this bill. And, but I think we all probably got this email, but we did have one that somebody was asking about possibly changing the effective date to immediately. So that way, if there's anything starting to get litigated or anything sooner, then this statute could apply. But I don't know if that, I'm like, again, I'm no attorney, guys. I don't know if that would set
Page
well or
9
not.
that you're looking at here on the bill?
So it would be page 3, lines 9. The effective date would become immediately upon this
Okay.
passage instead of July 1st.
I'll second that.
Second, if that was a motion, then we have a second by Singh, change the effective date to immediately. Representative Chesty.
Thank you, Mr. Chairman. I'm going to be opposed to this amendment. I just think that when we're changing, part of putting things in the green book is, I mean, we need to give the public notice, a little bit of advance notice, and law enforcement of the fact that this is now a new law, and it's going to take a little while to get things published and notice out there to the world. I just think that it's more typical to do things effective July 1st to give the world advance notice of what the change in law is. I'm going to be opposed to this amendment.
Further discussion on the amendment?
Mr. Chairman.
Mr. Vice Chairman.
Thank you, Mr. Chairman. I just believe that it matches the language that we've introduced in page 2, line 6. So, thank you.
Representative Chesty.
Thank you, Mr. Chairman. That's page 2, line 6 is covering a different transaction. This is, it's creating an element to the crime that people need to be notified about in advance. So so the word immediately on line 6 is talking about the person who committed the crime. If they don't immediately return, has nothing to do with the effective date of the bill. And I think because of, that's something that people need to know, that they have to immediately return, and we need to give them some advance notice of that. So I think that's why I'm still opposed to changing the effective date.
Further discussion on the amendment? All those in favor of Representative Filer's motion to change the effective date to immediately, say aye.
Aye.
Those opposed, no? No. I think that's failed. Not a real vocal group this morning, so. Further amendments? Seeing none, please call the roll.
Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestic,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
9 ayes.
Very good. Representative, it'll be your bill on the floor and hopefully get it through committee of the whole expeditiously.
Sounds good, thank you.
Thank you. Thank everyone for testifying on House Bill 111. That brings us to House Bill 194. We closed public comment on this bill when we heard it, seems like forever ago. And today we're going to just have the committee work the bill with proposed amendments, and then we'll take a vote on the bill. So, Representative Chestic.
Thank you, Mr. Chairman. Before we get too deep into the bill, I'd like to propose to the committee that we lay this back to the interim for a very specific reason. This bill is not ready for prime time. I don't think there's, if of all the bills that we've faced this session, we've gotten more emails on this bill than any other one on both sides, but largely opposed to it, very, very heavily opposed to it. We have in front of us a number of significant amendments that change the bill significantly, and it's going to take us a while to work through it, but even if we got through it, I think it's not fair to the community that's very invested and very interested in this bill to let them weigh in on these significant changes that are being brought forth. So I don't think we're doing the community a favor by rushing this through. And I think this bill could benefit from having a longer period of time to study it, work on it, take more testimony, understand the ramifications of it. And therefore, I would propose to table the bill and then ask for the Management Council to bring it back to us over the summer as an interim topic.
That sounded like a motion to table.
It's a motion to table, yes.
Okay, is there a second? I'm not sure we need a second on a motion to table. So a motion to table is not debatable. It's always in order. All those in favor of Representative Chestic's motion, say aye.
Aye.
The motion has failed. Further, Representative Chestic. Okay. All right. Committee, let's dive into 194. As I listened to the testimony and read through the bill, and there were several aspects of this that I think we need to have some conversation about as a committee and see if we can come up with language to address some of these issues.
Chairman Washut, was there a motion on the bill?
Oh,
Move the bill.
motion by Lean to move the bill. Thank you, Pierre, for reminding me. Is there a second on that?
Second.
And I have a second by Kelly. So the bill is properly before the committee here, so we can begin the debate. So there were several things in the bill that I think we need to spend some time on. One that we heard early on dealt with the repealers at the end that took out all the protections for schools, libraries, colleges, and so forth. And we heard testimony about colleges and universities really not being places where we have a lot of interaction with minors. There is some where we have students who are taking college-level classes before they turn 18. But for the most part, those are adult entities, and parents have to approve for their minor children to take those college-level classes. So I just wanted to throw that out there that perhaps we consider whether or not this bill needs to reach the college and university environment. Representative Brady?
Thank you, Chairman. I understand when you're talking about adults being enrolled in colleges, universities, but I'm concerned about little kids in the, let's say, the lab school, for example, at University of Wyoming. I think it should apply to that.
Further comment? Representative Bratton?
Thank you, Mr. Chairman. Is the lab school K-12, so that would be part of that provision, under that provision?
Okay, Representative Chestic?
Thank you, Mr. Chairman. The lab school is K-8, actually, and there could be possibly a carve out to include that. But so the issue here is, if I can find it in the bill, it's on, it's the repealer, the end of the bill, that repeals section 64302C2. Let me see if I can find the page 7 of the bill. Yeah, so I would move that we strike that line and leave that provision in place. The way it's, I have the existing wording right now is this section shall not apply to any person, blah, blah, blah. In C2, in the course of bona fide school, college, university, museum, or public library activities, or in the course of employment of such organization. So my amendment would be to take it out of the repealer, so it's not repealed, but then have another section in the bill, and we'll have to get also to put this in the right spot, that amends C2 to omit college, university, and museum. I think museum also needs to come out of there. So I would recommend leaving C2 intact, but deleting from C2 college, university, or museum. That's my motion.
So the motion is on page 7, line 22, to strike the repealer, put a period after 64302B, Romanet 2, and there'd be a period, and strike the remainder of line 22. That's the motion?
Well, and then also to add another section to the bill that amends, we're amending, elsewhere in the bill, we're amending C302C, C1 we're amending. We would add an amendment to C2 to leave it in, to include the existing language, but omitting college, university, museum.
Okay. My thought, and I'll just throw this out for discussion here. Let's see, do we have a second on Representative Chestic's motion? Second by Lean. So we can discuss. So my thought was maybe we could add it in on page 3, under 64302, we have C, this section shall not apply to any person who may produce, reproduce, possess, disseminate obscene material in the course of law enforcement, judicial activities, or in the course of medical, mental health treatment.
Right.
That we could also add in there in a section about colleges, universities, museums.
Yeah, so that's exactly where it should go. after line 23, we would include the existing sub-Romanet 2, but strike out college, university, museum from Romanet 2. And that would be, that's exactly the spot where you would put that.
Mr. Vice Chairman.
Thank you, Mr. Chairman. Correct me if I'm wrong, wouldn't striking college, university, and museum from that specific section make it applicable to the colleges, universities, museums, because this is an exception to the rule?
You might be, yeah.
Representative Chesty.
I think you're right. Good catch. So what we would do there would be, we would strike out bona fide school or public library activities. So we would still accept from this application, college, university, or museum. That's, you're correct. I got it wrong. I apologize. My friendly amendment, thank you for that. So yeah, leave the existing language in that does exempt college, university, or museum. Strike out bona fide school. Well, leave bona fide in too. Strike out school or public library. It has to be bona fide college, university, or museum.
I thought you didn't like bona fide.
I don't, and I was thinking about a committee of the whole amendment to because this is the same topic, and I will probably bring a committee of the whole amendment when I have a chance to think this through more, but yeah, well, I'll think about it,
All right,
but for now.
so the motion is that we strike the repealer language and then add in on line 23, after the semicolon following treatment, or bona fide college, university, or museum.
Yes.
About the second?
You have a second on that?
No, Lean seconded.
Lean seconded that. Pierre, do you have the motion? Are you clear?
So on page 7, do we have a period after B Romanet 2? Or do we strike the entire section?
So we're striking the remainder of line 22 on page 7 after 64302B Romanet 2.
Okay.
Put a period, no,
Yes.
don't put a period there because we're going to maintain the word repealed on the following line.
Oh, yeah.
But we're going to strike and see Romanet 2.
Yeah.
And so it'll say, so section 2 on page 7 will read, WS 64302B Romanet 2 is repealed.
Yep, I get that.
And then on page 3, after treatment, we're adding or bona fide college, university, or museum.
Okay.
Mr. Chairman.
Representative Chesty.
Actually, what we're doing on line, after line 23 is I think we should keep Romanet 2. We're changing, all we're going to do is leave this, when we take out the repealer, Romanet 2 remains in the green books. And all we need to do is amend the green book to take out the words school or public library. So you would simply restate the existing Romanet 2, which says in the course of bona fide school. So that's going to, and then, so you would repeat the existing statute, striking out the words school or public library.
So we would read,
Activities relates to college, university, museum, so I'd leave activities in.
so we would read in the course of
School,
side, college, university, museum.
yeah, right. In the course of bona fide college, university, or museum activities, or in the course of employment. We're just striking out the words school or public library activities, or public library.
Do you have that, Pierre? We're capturing all the language in C Romanet 2 without the words school or
Or
library,
public
or
library.
public libraries.
Okay.
Committee, everybody clear on the amendment? Discussion on the amendment? Representative Brady?
All right, just a clarifier. So so this won't then apply to museums and colleges, but schools and public libraries are still in. Is that correct?
Yes.
Yes,
Thank you.
we're exempting universities, colleges, and museums, but we're maintaining the applicability of this change in statute to schools and public libraries. Representative Brady?
Thank you, Mr. Chairman. So I'm sure you just answered that, but I just want to confirm that my question earlier about the lab school, that would be under this, they'd be subject to this bill, correct?
Representative Shestak?
The lab school is a school, actually. It's a K through 8 school. And it's administered by the Albany County School District Number 1. It's part of that district, in fact. The way it's currently configured, we're talking about that in another bill, but for now, at the moment, it is a public school connected with the Albany County School District Number 1. So I would interpret that to not be it's not a college, university, or museum. Let's put it that way.
Mr. Chairman.
Vice Chair Chen?
Thank you, Mr. Chairman, and to Representative Brady. So there is a bill right now to restore the lab school that's coming up, and we could definitely include that language to specify that students at the lab school would not be able to access the college library itself in that bill, but I don't think it would be necessarily applicable to this bill.
Okay, voting on the motion. All those in favor of Representative Shestak's motion, everybody clear on what we're doing here, Representative Webb?
So are we including the lab school or are we excluding the lab school?
The lab school, and I would agree with Representative Shestak, is still a school. So by striking schools and public libraries and only retaining the rest of that, the lab school would still fall under the prohibitions of this bill.
As long as it falls under the prohibitions, that's what I want to make
That's the
sure.
way we understand this motion, what the intent of the motion would be.
Thank you.
All those in favor of Representative Shestak's motion, say aye. Aye. Those opposed, no. That motion is carried. Further amendments to the bill. You know, one of the areas that perplexed me in this bill was who goes to jail. You know, we have the knowingly element because I think it's impossible that any library employee knows what's on every page of every volume in the entire library. So the, you know, young person at the front desk who's scanning the barcodes and putting your books in a bag, unless it's obvious on the cover of the book, has no idea what the content of that book is. So at least my way of reading this bill is that that person would not be committing a crime to check out the book and send it home with you. Okay? Because they're not knowingly distributing material that's harmful to a child. They don't know what's in it. Okay? So then I start thinking, well, who is committing the crime, right? And it also talks about make available. So, well, who made that volume available and knew what the content of that volume was when they made it available? So is it the library board? Do we have to arrest everybody on the library board? What if the volume came into the collection 30 years ago, still in the library? The members of the library board that may have approved that book might be dead, may not even be around, right? So if anybody has some ideas about, you know, who actually do we prosecute at a library for the dissemination of material harmful to a child?
That's a question.
Mr. Chairman, it would be my understanding that the head librarian of all of the libraries is the one responsible for the purchasing of the materials and should know the content there within.
And Representative Lean, I'd agree with that for newly arriving materials. But some of these collections have items that have been there for decades. So if you're the new head of the library, you're the new head of librarian, are you criminally accountable for every page of every volume in the library? That's my worry. Representative Brady.
Thank you, Mr. Chairman. Along that line of thinking, I know somebody goes through these books because there's always a rack outside our library that are used books. They circulate them. So when it comes to somebody just newly coming in and books may have been there for a long time, I believe they probably go through them, because otherwise why would these books be pulled and, that aren't being used and for sale or free or whatever? I don't see why we're not keeping them from analyzing what's on the shelves.
Yeah. Further discussion. One thought I had, when we talk about schools, I think it's a little easier that perhaps you could, designate the principal of the school perhaps as the person accountable for the library collection in a school. And then if there's something harmful to minors being distributed in that school, that we hold the principal of the school criminally responsible for that behavior. I think it's a little tougher on public libraries where some of these collections have been around, that they don't recycle all the books every 3 years, right? There's a lot of older publications still in that library. Books that were published, when I was a kid, there's probably still some of those in the collection. And I just don't know, as a practical matter, right? A book your kid brings home a book from the library and it's got content harmful to a child in it, and you call the sheriff and say, go get him. Who does the sheriff go get? Senator Kelly.
Thank you, Mr. Chairman. We don't know. Look at us. We're all scratching our heads. So, Mr. Chairman, no, I don't know what to do here.
Representative Brady.
Thank you, Mr. Chairman. I would assume, and I understand that, what everybody's talking about, but for example, who is the head person of a district? Would be a superintendent. Head person of a library would be the head librarian. Got to start somewhere if we're going to be able to impose some kind of penalty. So that's my offer.
Representative Filer.
Mr. Chairman, there's no way we can charge anybody. It's impossible. So yesterday I took 45 minutes. I drove over to my public library. I went to the children's section and I'm a thriller type novelist. I like reading about, everything by like Stephen King. He's one of my favorites.
You came to the microphone.
Sorry.
YouTube can hear.
Sorry, YouTube. But I went into the second floor of my library and I couldn't find it, right? So I went to a third floor of that library and I found that book. And I found it. I found a book written by Stephen King. And it's restricted to any minor. So no minor can rent that book or check that book out. And then I also drove over to one of my neighborhood schools. And I couldn't find a single book that anything that I could tell that was explicit or anything of that nature. But when we're talking about creating a criminal offense against somebody, our public library, a lot of our books are donated. I, for one, had bought a bunch of sporting novels at an auction, and I didn't know what to do with them, so I donated them to my county library. Some were very old books, I don't know. So am I the one that donates the book to the library? If, I don't know. I mean, does the crime come all the way back to me, Mr. Chairman? Knowingly, maybe I might have knowingly that there might have been something explicit in that. I also have donated the Holy Bible to my county library. Has anybody ever read that book all the way through? Are we here to, I just don't know who we can charge with a crime on something like this because it goes too deep. It goes way too far. What if a parent allows? Do we charge a parent for allowing their freedoms and be able to teach their children something with a book if they want to check it out? I mean, who do we charge at the end of the day? But I also know that there is a system set up in our public school system. When one of my kids checks a book out in their school library, I get an email right away. I get an email immediately. I know what my child's reading. And at moments of notice, I could say, nope, turn that book right back in. I have those rights as parents. I get trying to keep and shelter our kids away from some of the nastiest things that we've ever read about or seen or where our progression in society grows. We passed a lot of bills to help stop a lot of the stuff where the kids are actually getting the information. That's sitting right here. It's sitting right here. It's not our public library. It's not our school library. It's right here. We use this communication device to look up everything in the internet and now we have passed laws in the House so far. I mean, they're going over to the Senate, Mr. Chairman, that restricts that, where we're gonna have to do maybe age verification, where there's more controls over what our children are really getting at. Or are they sitting on their tablet in their bedroom on YouTube? I mean, let's really think about what we're doing here. I totally get trying to shelter our children from these types of things. But at the end of the day, are we gonna put people in jail, starting with the person that donates a book? Because we really don't know, committee. We don't know who we're gonna charge. We can raise the torch and say that we're protecting children here. There's no doubt about it that we're trying. I think the intent of this is to protect our kids all day. But is the unintended consequence, we're just gonna start arresting people? Charging them? Charging a librarian? A librarian. They don't, last I knew, a librarian does not read every single book in a library. Folks, I I think this is a true problem that we have in the state of Wyoming. I really do. And this has been an ongoing thing for years and years and years. But let's get to the heart of it. Let's get to the honest heart of it. If we do something like this, we will end up having to arrest somebody for allowing a child to read the Holy Bible. Sorry, Mr. Chairman, so I don't know who we charge. I don't know who we charge.
Representative Cheston.
Thank you, Mr. Chairman. And I agree with my colleague down the dais here. We don't know who we arrest. We don't know. What do we do? So what do we do is we vote against this bill. This is a very, very dangerous bill. I trust our librarians. I really do. They do a great job. They provide a great service, and they're supervised by the library board. So maybe we arrest the library board for allowing this book to be in the library. Are we going to arrest all those citizens, those volunteers? No. There are checks in place. This is not a Wyoming problem. This is not something, it's the parent's responsibility. So we've heard a lot about parental rights this session. The flip side of parental rights is responsibility. it's the responsibility of the parents to know what their children are looking at and reading. And there's procedures in place, as my good colleague to my left here just said. He gets an email when somebody checks a book out. The parents know what's going on, and it's their responsibility. And it's not the job of the library to say, well, some people might object to this, so people who don't object to it can't see it. That is not the job of the library. The job of the library is to be neutral, and they do a good job. They do a great job. And I therefore am strongly opposed to this bill and urging no vote.
Representative Kelly.
Thank you, Mr. Chairman. I think it's also important, though, we don't lose sight that this issue wasn't conjured out of thin air. We don't have complaints across the state and parents getting riled up in library battles in different counties because some boogeyman was just invented for the fun of it. There's a serious issue here. I'm a parent. I have a child who has Down syndrome and sees something in a book and immediately tries to mimic what he sees. I don't want him seeing this type of material either. I don't want it in a children's library. There's a serious issue here, and I think if it had been addressed more seriously, instead of deriding parents as bigots and book burners, that we wouldn't have gotten to this point that we're in a state committee meeting talking about passing a sweeping and almost vindictive law. And I agree with the intent of this bill, and it's something I want to vote for, but we have a serious issue, so I need people to understand that I feel the pain of this. I know what the genesis of this bill is. But when we come down to the fact that we don't know who we're going after, we're swinging in the dark here. Anyone who disseminates, furnishes, presents, provides, makes available, gives, lends, shows a fellow student, hey, Billy, look at this. Is that kid now a criminal, according to this bill? We don't know, and that's the issue.
Representative Brady.
Thank you, Mr. Chairman. A couple of points I want to go back over. Regarding the cell phones. The cell phones aren't paid with public funds. So I don't know how you're trying to associate that with this bill. And again, it's up to the parent. But the parents pay for taxes, and they're trying to control what's going on in the libraries. Perhaps we can make an amendment saying, giving the school, the library, schools, whatever, 6 months or a period of time to review all of their, whatever's in the inventory. Get out whatever the issue is with these. And also, I'm also referring to the handout from Ms. Collier regarding what books have been found in Wyoming schools, for example. I know I'm jumping back and forth to libraries and schools, but they are there. Whether you can find them on the first, second, or third floor, they are there. And that's what this is addressing. So that's my point. Maybe we can do an amendment that gives them a period of time to clean them out. Thank you.
Representative Fowler.
Mr. Chairman, not just a little bit of pushback on the cell phones, all that. They're not paid for by public funds, right? They're private, you know. I pay for my kids' cell phones every month. But we also just passed laws in this committee to restrict what I can have my children do on this phone that I pay for, okay? So that's with private funds. Also, our county libraries, folks, is not all 100% books paid for by public funds. They're not. I donated over $10,000 worth of books in the last few years to my county library. And this is $10,000 of my private money that I donated to that library because I believe in that library. And yes, if you go to that second floor, I challenge anybody on this diocese to go to that children's floor. And my public library that's ranked number 10, within the top 10 in the nation, right here in my county. I challenge any one of you to go over there, and I want you to ask the librarian, where can I find the explicit material in the children's section? I want them to know where they're at. And then let's all go look. Let's take a field trip. Let's go look. And whatever books we find on this diocese that we do not like and we think is wrong for our children to read, now I want to go back around and I want to talk to every single child's parent in my county and say, what do you think? Should we tell you what you are allowed or what your child is allowed to read? We want to take this parental right away from you. But if you do allow your child to read something like this, are we going to put the parent in jail? Again, we still don't know. Leads down a path of unknowns. So many unknowns. I see the emphasis of this, and I think it was a national issue where a lot of people have feelings in their beliefs and their moral beliefs. And I totally understand that. And I have moral beliefs in my family, and there's no way I would let one of my children read one of my Stephen King books. I won't. I'll never do that. And if they check one out of a library, I'm gonna get that email and I'm gonna take it from them and I'm gonna go return it because I am that much involved in my child's life. And I believe in those choices. I do not need this diocese or this government to tell me how to raise my children or try to put me in jail for it. I don't need this. And this might be that libertarian side coming out in me. I don't know. But at the end of the day, we should be writing laws that give the freedoms to those parents and those choices, just like we've done with education and everything else. Let's keep the parent involved. Let's not take the parent out of the equation. Please, folks, this is just, so remember, private funds, public funds, a lot of these libraries, they're helped out with a lot of private funds. So it's not all just public funds. Thanks, Mr. Chairman.
Yeah. I think Representative Webb on the end, then we'll come back to the vice chair. Members, I was a little afraid that this might happen, that we're going to have a whole lot more discussion and less working of amendments and so forth. But I think that points to some of the challenges that are before us, that we recognize, and I tend to agree with Representative Kelly. This issue didn't just show up out of thin air. There were issues at some of our schools and some of our libraries, and sometimes the local solution has not been completely satisfactory. So the issue's out there. It's not just make-believe, but Representative Webb.
I don't know if it's appropriate at this time or not, but I was interested in Representative Chestic's thing about laying this back until the time that we can discuss it during the interim. And I think we've made some progress, and I think we've needed this discussion that we've had today. But I think we need to not discount that maybe we want to discuss this further because, yeah, there are serious consequences, there are serious topics that we need to discuss and try to come to some type of resolution.
Representative Ling.
Thank you, Mr. Chairman. I just want to say that I know that there's a rating system for these books already in place, much like we have one for movies. And we already do this with digital content, so why would we not do it with books? I also want to say that there is a person to charge. If we go to page 4, line 2, if you strike a person and insert a library director or head librarian, now you have somebody to charge. And then somewhere in this phrase, I would also like to give them 6 months, 8 months, a year, a time frame to be able to clean out those shelves, to be able to monitor their content. So then you have the ability to make sure that they're not knowingly disseminating information. As far as these books not being at our children's fingertips, I just want to draw your attention to one that has become very popular recently. It's called Wicked. And the musical is phenomenal, but if you read the book, there is sexual content within that book that is not good for our children. And that is intentionally targeted at our youth. So if you put that book and you walk into a library and you see it, the cover of it is very captivating. And it is for our youth. It is targeted at these 14, 16-year-old kids, 12-year-old kids. But the content within it is not acceptable. And our parents have spoken out. Our parents have said, we need to clean this up, and they're getting pushback. This is where the pushback comes. The American Library Association gets their community standard test or the Miller test from a national organization. That national organization is a blanket for Detroit, Baltimore, Las Vegas. And those standards don't belong in our townships in Wyoming. Those standards are bringing in big city problems to our small towns. There are cultural aspects that are great within our libraries. They expand our knowledge, they expand our imagination and our innovation. But pornography exposure to our children is harming them. We had a mom sit here and tell us her very personal story, and I don't discount that. I would push back on laying this back. I would motion that we can amend page 4, line 2 to insert library director or head librarian, and that we insert an 8-month open to suggestion, or a year clean out phase for our shelves for the librarians to have an opportunity to go through that.
Do we have a second? Second by Brady. So here's my concern. If we change person, take person out, and now narrow this down to just library directors, library head librarians, then all these other aspects of events and displays and shows and all this does that too only apply? Does the rest of the statute of promoting obscenity only go to library directors? That everybody else in the state is free to share this material with children? And in terms of the timeline, you know, if you're the Goshen County Library, 8 months is probably easy, right? If you're the Laramie County Library, where a lot of volumes, if you're accountable for the content on every page of every volume in your library, even if we gave them 8 months, I'm not, assuming you had no other duties, no other responsibilities to perform, you could spend the next 8 months looking at every page of every book in your library, because we're going to say you're criminally responsible if you miss something. So Representative Chesty.
Thank you, Mr. Chairman. Addressing the proposed amendment, this is another example, I think, of why this bill is not ready for prime time, and it would benefit from a more sober, lengthy, objective study over the interim. If we adopt this amendment, we're not going to have any head librarians. We're going to have a lot of vacancies we can't fill. If taking the job exposes you to criminal liability for collections you don't even necessarily know what's in them, we're not going to be able to fill our library positions. It's a direct assault on the governance of libraries that I think we need to think that through, and I'm opposed to it.
Representative Kelly.
Thank you, Mr. Chairman. Pertaining to the proposed amendment, I like the spirit of it, and it makes sense, and it does narrow the bill. But we'd be swinging at what I call a moving target, and we've seen this in the world of politics. If we were to specify head librarian or library director, then we would no longer see head librarians or library directors. We would see resource facilitators or some other title. So that's an issue when we get over specific with a target like that.
Further discussion on the amendment? Hearing none. So Pierre, do you have the amendment clear? The timeline language, Representative Lee?
Yeah, I'm not sure where to put it, but I would just, language to the effect of library directors and staff have, let's give them 12 months to review content and separate or remove literature.
So Representative Lean, is the intent there that there then becomes a presumption that after that 12 months, if they check out a book from that library, and it's then found to have content harmful to a minor, which I want to emphasize is different than the Miller test, right? Miller test is for obscenity for adults, so here we're talking about harmful content for minors. So if we give 12 months to review and remove, then that creates a presumption that any item remaining in the library is free of content harmful to minors, and if anything is then disseminated, whoever disseminates, whether it's the 18-year-old minimum wage clerk at the front counter or the head librarian, or the legal consequence still restricted to the head librarian only?
Mr. Chairman, the library directors are the ones that ultimately put out the purchase list, review the content that's staying on the shelves, and have oversight of their staff. This would be much like a store manager. That library director also talks back to the library board. They attend all of the board meetings for the libraries. All of the libraries currently have a challenge process in place so that once you have content that then comes back to the library as a challenge process, that challenge process then goes back to the library director. The director and the board all read that and review that book. It gives them that 60-day timeline to be able to decide if that information is truly harmful or if it has the opportunity to stay on the shelves. And so there's a process in place that's already not written into this language that has to do with the bill. So as this bill reads, you would give them that 12 months to clean up the library. And then by putting in the library director or head librarian on page 4, it would come back to them as the oversight of the literature within the libraries.
Representative Lean, would you be open to maybe putting a date of acquisition so that rather than saying you're responsible for every volume and every page of everything in your library, say all materials acquired after January 1, 2024 forward have to be reviewed within this time frame? Does that run a risk that we have some older stuff in there that perhaps has content harmful to a minor? Perhaps, but we stop the flow of incoming material and we give them a reasonable amount of material to review where we think perhaps the most problematic. I'm thinking, I don't know what the time is, but 2-3 years worth of acquisitions, every book that's been acquired by the library, not $10,000 worth of books donated by a good citizen, but maybe that makes it a more manageable lift than to try and review every page of every volume in the Laramie County Library. Your comment?
Thank you, Mr. Chairman. I would be open to a date of acquisition. I would think that because of how often libraries do review their content for things like book sales, like Representative Brady talked about, I would say a solid 10-year period wouldn't be unreasonable. So on that amendment, for the 12 months, date of acquisition being materials January 1, 2015 and newer.
Does the second agree with that amendment to the amendment? The second does. All right, so where are you putting this language over there, Pierre? It sounds like kind of a conceptual amendment, but where are we putting this?
It's going to be consensual, and I think the attorneys will decide.
Okay. Further discussion on the amendment? So the amendment changes line 2 on page 4 from person to library director or head librarian. And then we have a conceptual amendment that libraries would have 12 months to review and remove materials that contain content that's harmful to minors, as described in the bill, and any item in the library acquired after 2015 would be subject to this.
Mr. Chairman,
Representative Lean?
instead of, I'm not sure how you said it, remove, I said remove and separate, or separate, so that the public
or
libraries could move it to a separate area, so that if parents want their children to have access, they absolutely could, but the school districts would be required to remove.
So this would apply to librarians in schools as well as public libraries?
Yes.
Okay. And does this have any impact on the rest of the bill? If somebody else is outside of a library or a school is providing materials that are harmful to a minor, are they not then subject to the distribution? Because we're amending the statute that deals with disseminating or distributing so I guess I'm not clear on whether or not if somebody else outside of a library or school wants to host a live performance or exhibition that depicts sexual conduct, sexual excitement, sadomasochistic behavior or abuse to an audience that involves minors, is that now going to be okay? As long as you're not a head librarian, or I just worry about the effect of this amendment on other aspects of the bill. It's just a question. But we're about out of time, so let's take a vote. All those in favor of Representative Lean's amendment, as best we understand it, Representative Brady?
Thank you, Mr. Chairman. If I might, if we consider it a friendly amendment, but under D, where it's knowingly, could we also include or purposefully? Page 4, line 4.
We can do whatever we want, but we've got 3 minutes. Representative Kelly.
There's another aspect of the amendment we haven't even discussed. We're talking about that 1 year to review the last decade worth of materials, and there has been no opportunity for input for our public institutions to say what kind of a lift that would be and how they could do their day-to-day activities and then go back and retroactively review the stuff from the last 10 years. I'm not saying whether this may or may not be feasible, but we're not going to find that out in the next 2 minutes.
Mr. Chairman,
Representative Lean?
I respectfully withdraw my amendment and move to table this for an interim topic.
Motion to table. All those in favor, say aye. Aye. Those opposed, no. Bill's been tabled. You know, just some concluding comments. As a citizen legislature, we always have challenges. You know, we only get together a couple times every 2 years. We get 500+ bills, and we have, you know, just a few weeks to move all those bills. I think the interim topic is valid. We'll propose that to Management Council and see if we can really spend the time necessary to try and make a workable bill here. Thank you.